And welcome back to the Law News Network, everybody. This is Aaron Keller. We've been listening to the Aaron Hernandez trial out of Boston, and I want to bring a guest in who's been keeping pretty close track of the developments over the last couple of days. Deborah Blum is a defense attorney, and she's been watching, and you think the defense is doing an excellent job in this case.
Yes, I think that today took a very positive turn for the defense when Jose Baez questioned the detective that was on the stand. A lot of doubt came out. Would you?
Yeah, elaborate on that, because I will admit that I didn't see everything this morning because I was coming into work. Take us through the process, because the only thing I've been seeing is a discussion about the chain of exactly where this Toyota 4Runner was from the point of the shooting up to when police found it. So this morning there was a pretty critical attack, though.
There was. One of the most important things is that it came out through the questioning, the cross-examination, that the two survivors left the scene of the shooting. So when most people, God forbid, get shot, they're going to stay there and wait for the police, wait for the ambulance. So the defense is going to be able to argue that these people were involved in illicit activities themselves, because people that are involved in illicit activities don't want to go to the hospital because they know they're going to be questioned. Because when a gunshot wound goes into a hospital, the hospital has to call the police, and then the police come and question those individuals. And then another interesting thing that came up is, despite the fact that the police linked Hernandez to this years later, they still could have gotten a subpoena for his phone. And nowadays, in most prosecution, especially in the cases I'm handling currently, a very big part of the prosecution is tracking the defendant's movements. So it's pretty surprising that a case of this magnitude, that the police or the prosecution did not subpoena Bradley's phone records or Hernandez's phone records. So that's pretty shocking to me, because the technology that we have, even in 2012 when this happened, would show where they were. And another thing that the defense brought out was, yesterday the security guard from the nightclub testified, and at one point he said that around 2:30 a.m. he believed he saw Hernandez on the street, which is very close in time to the shooting. So if Hernandez was on the street at that time, there's a question as to whether he could have done this. And another thing as to whether he did this is the fact that the people who witnessed this did not give a description of Hernandez. One gave a description of a woman with long hair as a passenger, and another gave a description of an African-American man being responsible for the shooting. So that does not match Hernandez's description.
A lot to unpack in that analysis. We talked about the descriptions, we talked about the phone records. I want to dial back to one of the first things you discussed about this thing about some of the victims leaving the scene. Now, yesterday we saw this insinuation that some of the other folks involved in this case had potential gang connections, and then the judge shut that down, and then we're seeing it raised again. So does this get into whether or not Hernandez was even had a motive, maybe, or is this more third-party culpability?
Well, we're going to see when the defense rests what they're going to, their narrative that they're going to tell to the jury. To me, it seems like they're trying to say that these individuals were involved in acts of criminality themselves, that they were gang members, they were drug dealers, and that it was a drug deal gone bad. So by highlighting things like they left the scene of the accident, most people wouldn't do that. Mainly somebody that's involved in criminal activity would think to themselves, let me get out of here. Most people in shock aren't going to have like the mental process to decide to get up and flee. So I think that they're going to argue it wasn't Hernandez. That's one part of doubt, that these people had other people after them, that Hernandez potentially wasn't even driving. So there's a lot of doubt.
A lot of people have been paying close attention to this. Do you think it's because of Baez's star power? People want to see him in action again? Is it the defendant being famous? Is it just that there are so many what ifs in this case?
I think there are a lot of what ifs in this case. Also, we have Hernandez, who's gone from the NFL to the cell. He's already a convicted murderer, and now he's accused of 2 other murders, which happened before, right around the time that he got his $40 million contract.
Yeah, I mean, a lot of what ifs in this case. We've also been covering the War Machine case out of Las Vegas, and I've been paying a lot more attention to that one over the last week. In my opinion, the defense has been all over the place in that. We've seen a relatively rambling opening statement by the defense in which the defense comes right out and says, you know, our case won't make any sense until the closing argument. And I'm sitting there saying, how is that a defense strategy? When you defend a client, do you ever make an opening statement and then say, yeah, members of the jury, this won't make any sense until we're all done with the evidence?
Well, that brings a smile to my face because it reminds me of my days at Legal Aid. I worked at the Nassau County Legal Aid Society, and our supervisor, Jeff Sorge, had this wealth of material that we got these packets. And one of the things that we got a packet on was giving an opening statement. And there's a type of opening called the non-opening opening, which you don't get into too many facts of the case for various reasons. So it's possible that they gave a non-opening opening, but it was relatively unorthodox in this case. A lot of things have been really unorthodox, such as their lack of objections to the prosecutor.
Yes. That's been strange. Lack of objections to the defense in large part. I want to go back to this. I have never, in my time in law school, my time licensed as attorney, ever heard of a non-opening opening. So you've got some little trick or tactic here that I've not yet discovered.
Well, there are a lot of ways to sharpen your skills as a defense attorney, and that's one of them. You have to assess many different factors. There are so many things that go into a trial. A lot of those things are the sidebars, or when the judge takes a break to speak with the prosecutor and the defense attorney. So there's so many factors that are going to affect your opening and then ultimately your closing. And then another really crucial part of a trial is destructive cross-examination. I do think that they had some destructive cross-examination today.
In what sense?
Yesterday. In the sense that they were getting into the fact that this couple was looking for a sex slave. There were text messages that they questioned Ms. Mack about whether or not that was true, and she admitted, yes, that is true. It's something we're considering. They're trying to paint a picture that this couple had an extremely unorthodox sex life, and that this was part of their sex life, that this terrible beating that she suffered, it's as if she asked for it. That's what they're trying to say, that she wanted this.
Yeah, I mean, we've discussed that possibility, but then at what point does the jury just throw that out and say, you know what, that's not what happened here, because it's been clear from the state's direct examinations in almost everyone else's opinion, and I'm curious as to yours, that there was a line between what was unorthodox but consensual and then what results in multiple broken bones, the loss of several teeth, lacerated organs, and broken ribs. I mean, I think the state's done a pretty good job, again, in my opinion, of drawing a line between what was unorthodox and consensual and that.
I think that of these high-profile prosecutions, this prosecution is doing the best job because they are painting an accurate picture. They're having her explain everything. They're bringing out things that are damaging to her on their own direct examination. So she's explaining everything, and she's a very likable individual, and she also gets into the fact that she was a victim of domestic violence. So the judge allowed the prosecution to get into prior uncharged acts of domestic violence, and there were just so many of them.
And we've talked over the last couple of days about how the prosecution actually opened up the window of time for the charged offenses in an amended complaint so that they could bring those in in without having prior acts objections coming up from the defense. And, you know, what you're discussing leads into the other point. The rules of evidence specifically say you can impeach your own witness on direct examination. And, you know, I always thought that was the absolute correct way to do it, because it gives you the power to control what's coming out of your own witness's mouth, and to say, okay, yes, I'll admit that I did X, Y, and Z wrong, but this is what was done to me. I am more sinned against than sinning. And it allows the state to control the narrative if the state impeaches the state's own witness.
Well, I think in this case, they haven't really needed to do that, because she is being forthright with information, and she's going through a bucket list of horrific acts of domestic violence against her. So the defense here has allowed the prosecution to ask her an incredible amount of leading questions. When you do direct examination, it's supposed to be an open-ended question, and the prosecution has led her every step of the way.
I thought that was a bit odd, but I can understand why it was allowed to happen. What really confused me was the degree of open-ended questions the defense asked of the witness that they were cross-examining.
Right. Usually in cross-examination, your aim is to get a yes or no answer, or a simple answer. You don't ever want to ask a question that you don't know the answer to. That is the #1 rule on a cross-examination.
And we have seen it time after time after time after. I lost count after probably the 20th.
Yes, I'm really not certain what's going on here. I don't know if they're trying to set this up for an ineffective assistance of counsel claim, but you have an ethical duty to defend your client zealously. So, you know, we're not there, we're not at the sidebars, we don't know what the judge's rulings are. Maybe there's a reason that all of this is going on, but I really can't think of one.
Some have said that because there were objections during the opening statement, that the defense attorney feels as though he's on a unreasonably short leash.
Do you know how many times I've been objected to during opening, during closing, but you still have to do your job, and that is to zealously defend your client.
Is this defense attorney doing his job, in your opinion?
I don't want to say, you know, we're not there. I think that the defense in Hernandez's case is doing a much more exemplary job.
It's more textbook example worthy, perhaps we could say. The War Machine case has confused me as to the defense's strategy as well. They have towed up to strategies and then turned around and said in questioning, well, I know I asked you about that, but I didn't mean to insinuate that you set this up to try to raise your profile as an adult film actress. So why go there and then say, oh, I didn't mean to go there?
I think because there's a scope of what you can and cannot get into. So I also thought that was really interesting, that they touched upon the fact that she even has her own emoji with bruises. Mm-hmm. So they're trying to insinuate that she set this up, that she wanted to be beat up, that she wanted to get sent to the hospital so she would elicit sympathy and become a much more popular public figure.
Most of the defense witnesses that are on deck are forensics experts who we are waiting to hear from once the state rests its case. What does that tell you about where this is going to go from here?
Well, this defendant would have a hard time testifying to defend himself because he has prior convictions, and most likely those would come up, and they're very similar in nature. So it's going to be a difficult call for the defense. It's always a difficult call. Should I have my client testify? He's not going to testify here. So in terms of the forensic experts, probably they're going to try to paint a picture that this was consensual sexual relations, that the bruises are consistent with people that would be having a fetish type relationship. That's really probably where they're going to go.
They went that way a little bit in the opening statement, so we wouldn't be surprised to see that come back in. But they have gone there and then said they weren't going there, and I've just been sitting here saying, huh? I mean, where are you going then if you're going there and then not going there?
Well, sometimes, unfortunately, as a defense attorney, you get handed a case that's really just a loser. that it is close to impossible to win, but in a case like this, they're also not going to get an offer. So the prosecutor is going to hold them to the max. So there is no point in them accepting it without putting up a fight.
And there were a couple of plea offers here, but the penalties were relatively stiff if you look at the potential penalties for the charges that are in the statute book. So, you know, if you get an offer, let's say the maximum penalty is 2 to 15, and then the state offers you 10, then why plea? Might as well chance it? Is that the strategy?
I have a feeling that the offer was a lot worse than that. I'm not familiar with what actually was offered, but
I think one of them was 16, and I think the other was 10, but I know someone who's watching is going to correct me. I just don't have it in front of me right now.
They probably were back-to-back, meaning he would have to serve the 16 years' time, and then he would have to serve another 10. So I'm sure that they did an analysis of what he could ultimately get versus what he was offered. Or he might have wanted to go to trial, because if it was that, then he might have been better off taking what was offered to him.
Let me ask this. I floated this theory and wasn't sure if I was crazy or not, but Christy Mack has testified that she is not in love with this defendant anymore. But the defense has come out and said that he is still in love with her. Is that influencing decisions in this case?
It could be. The worst thing for someone who's charged with a crime is to make decisions based on their emotions. You have to assess the outcome. And in this case, there are so many prior acts of domestic violence. She testified incredibly well, detailing this incident. You have another individual who was present, who also was beat up. You know, originally when this case first started, it seemed like the defense was going to say that her boyfriend attacked War Machine. But it doesn't really seem like they're going for that defense anymore.
Exactly. I'm getting a note from Rachel Stockman, who's our editor-in-chief here. One of the offers was 18 to life, and another I think was 16 to life. If I'm reading my message properly here, so I'm just trying to remember the numbers of the offers, and so it's potential. There is a potential here that if the defense knocks out a couple of the counts, then some of the smaller counts would perhaps stand, where the testimony is a little more clear cut, and it could be less of a sentence in that case. So we think that what we've heard is that we may hear from one of the last witnesses in that case. Again, here's what happened. We've had some testimony from a business partner of Christy Mack's. We have heard some testimony from one of the police officers who gathered many of the photographs of Christy Mack herself immediately after the attack, and also who took photographs of the crime scene. He was testifying when they took a break for lunch, and they left. And I think what we're probably going to hear from in that case is we may hear from that police officer, or I should say we're expecting to hear more from that officer after the break, and then they're going to go into these two witnesses that we cannot show you. There are a couple of witnesses who have requested that they not be identified, they not be photographed, they not be televised. The judge is honoring that request and putting a ban on that type of coverage. We can report what they said after the fact, but we can't show it to you live. So that's going to be a bit tricky for us, but we're going to do the best we can for you. So that's the current status of that. They're actually in their lunch break, but we're anticipating that they're going to come back out of it here probably around somewhere between, I think if I'm remembering my math properly, the next 10 or 15 minutes. So what I'd like to do in the interim is go back and play a bit of a clip from yesterday, because we did have some good testimony from Christy Mack yesterday about whether or not she would have traded social media followers for this attack. In other words, did she somehow either lead the two men into this attack so that she would create a rage situation, or did she somehow want this to happen so that she would become, in essence, the most famous adult film star in the country right now? And the witness handled that very, very well. So let's play that clip now, and then we'll talk about that.
Thank you. Just 1 second, Your Honor. showing you 199. Was this the picture that you took after you had been recuperating?
Yes, it is.
And showing you 198. Was this a picture of you in the hospital?
Yes, it is.
At this point, your eyes were swollen shut. You stated you could see through maybe a slit in the right eye.
Yes, in my right eye, I could open it a little bit.
Was it worth it?
I'm sorry, was...
All those Twitter followers you got, and all those Instagram followers, was it worth it?
I wouldn't want to do that. I would not want to almost die for a few followers.
Nothing further.
Recross. Do it approach. Yeah, come on up.
Testimony on cross-examination of Christy Mack describing this rape fantasy lifestyle, the choking, the system of safety that was worked out. So this is about 5 minutes long. Let's listen to this.
Part of the fantasy would have been the element of surprise, correct?
Well, along with rape fantasy or role play, there is communication, consent, and safety. And those are all aspects that we would need to go over if something were to come to fruition. I may not have gone that in depth in the text messages, but had we decided to act this out or, continue to move forward on this, fetishization, we would have discussed it further.
You would agree part of the idea behind rape is surprise?
Yes, that is correct.
How did John respond to the idea of the rape fantasy?
Well, we obviously never acted it out, so I don't remember how exactly he reacted.
Well, did he seem disgusted by it and no, I would never do that?
No. I don't believe he would ever say anything like that sexually ever.
Right, he would.
He's very open-minded.
Yeah, I think he would. It's fair to say he would be game for anything like that.
Yes.
Did you ever pick a safe word?
No, we did not go that far.